But our top focus, the three-judge bench of the Supreme Court is hearing the mercy petition filed by 1993 blast death row convict Yakub Memon. This after two-judge bench was split on his plea yesterday, seeking stay on execution. Now, the new bench will decide whether to stay the death warrant issued by the Tada court. It will also decide whether Yakub's curative petition will be heard afresh. With the hearing underway in the Supreme Court, the 1993 blast victims have also filed a petition with the governor. Now, Yakub has argued that his good conduct inside jail should be considered and that his death warrant was issued without exhausting all legal remedies. While the Attorney General has contended that Yakub has availed of all legal resources and options available to a death row convict. All right, and Supreme Court lawyer Kapil Sankla is with us. Kapil, you've had a long morning with us here, but who better than you to make us understand what's really happening in court right now? What are the options before the Supreme Court? It's very premature to go ahead and even talk about the judgment which is due, but just take us through the options before the top court as far as Yakub's petition is concerned.
You see, yesterday the two bench of the Apex Court could not come to a decision, and therefore under those circumstances the Honorable Chief Justice constituted a special bench of 3 judges.
Yes.
Now the whole idea is that the questions that were raised by the judges yesterday would be decided by the court today. And the questions are questions of law. And the questions of law are twofold. One, whether the curative petition was heard by the right court. The bench that was constituted was just and proper in terms of the precedent that has been laid down by the Honorable Supreme Court way back in 2002 in Hora versus Hora. And the second aspect is whether the death warrants that were signed correctly,
yes,
and within or was there an undue haste. This comes from a May 2015 judgment of the Honorable Supreme Court itself, which is the Shabnam and Salim judgment. So now these two questions, these two material questions will be decided by the Honorable Court today in the framework and the light of what would be argued by both the state as well as the counsel for the defense. Now,
could this have an impact on the execution which is scheduled for tomorrow? Because we've heard KTS Tulsi and others talk about how this could impact the date of execution for Yakub Memon. Obviously, again, we're not preempting what's going to happen,
yes,
but could this, you know, it's less than 24 hours now, could this have an impact on the execution date?
You see, that is anybody's guess. But having said that, as far as I understand that the bench has given its mind that they would give a decision today itself. So this way or that way, the court is going to decide whether it is going to stay the execution or put the matter back before the curative bench or decide it against the defense and in favor of the state. So therefore, going by the decision of the court in all three circumstances, the decision would actually decide whether the hanging would take place tomorrow or not.
Now, given that a convict on death row can keep applying for petitions, I mean, can keep going up to the president through petitions and wanting a mercy. In this case, what we have is Yakub has once again petitioned the president, but it's a bit too late, isn't it? And the grounds on which he's asking for the mercy is based on good conduct. Now, this is something that would have been discussed earlier while the matter was in court and not at this stage when it is with the 3-judge bench.
Oh, absolutely right. In fact, this actually seems to be a desperate measure.
Yes.
Having said that, you see, there is a very peculiar fact before us that the law so allows an accused to move for clemency or mercy petition before the president as well as before the governor of a state.
Yes.
So that being there, theoretically you can move innumerable petitions,
yes,
but practically that is not possible because you do have to show either a subsequent fact or an important fact that was not pleaded before. So therefore, what is being argued today has already been decided and already been discussed, and I think has been laid to rest by the President of India.
All right, do stay with me. We also have senior lawyer Akhil Sibal joining us at this point. Akhil, right now we believe closing arguments are continuing in the Supreme Court and we are expecting hopefully a judgment. But just take us through the premise of this case really, because for the layman, for the viewer to understand what really is happening in Supreme Court today, especially after yesterday, could be a bit convoluted.
Yeah, I think that there's perhaps a misconception at the moment,
yes,
amongst lay persons that that the issue is now going to be set at large again, or there's some sort of reopening of the entire case, which is of course not the current position. There is already a conviction which has been upheld there is a review of that which has already been rejected, and now the question before the court is whether the curative petition that was also rejected by the court was rejected by all the judges, or was rather placed before all the judges before whom it ought to have been placed. So the Supreme Court rules require that a curative petition, which is sort of the third attempt on a very, very narrow ground to relook at the merits of the case, the rules require that it should be placed before the three senior most judges of the Supreme Court, as well as the judges who had heard and rejected the review petition, if they are available. In other words, if they have not retired. Now, in this case, what seems to have happened is that the curative petition was placed before the three senior most judges, but two other judges, Justice Chelameshwar and Justice Joseph, who had rejected the review petition, were not taken into confidence and did not participate in that decision.
And Akhil, perhaps that's why we have a divide. That's why we also perhaps have a divide within the legal fraternity over the case today, isn't it?
That is absolutely correct, and again we should not misunderstand that the two judges yesterday took divergent views on merits. The divergence of view between Justice Dave and Justice Joseph is on the narrow point that Justice Joseph was of the view that a matter of procedure of this kind in a death sentence case has to be strictly adhered to and strictly observed. And he therefore felt that since the earlier petition which was rejected was not circulated to all the judges who ought to have taken a view, therefore it has to be considered again. He did not comment on whether on merits there should be a reopening or not. His focus was on the lapse in procedure that was followed. So it's on that very narrow issue that the three judges today are really considering the matter, and so therefore there's a very small window. What appears to me to be perhaps the strategy, and you'd have to ask the lawyers concerned, but the strategy seems to be is that somehow if the particular death warrant for a particular date, that is tomorrow, is set aside on some procedural lapse, then perhaps the renewed mercy petitions that have been filed would have sufficient time to be considered by the President or by the Governor, and a fresh view perhaps taken. It does seem to be a last-ditch effort, but it's that small window that is sought to be exploited in this case, and therefore it's a very narrow window.
And a very small window, in fact, Akhil, as we speak. But before I go back to our other senior lawyer in the studio, Akhil, what Yakub is now saying is that there was a problem in the process of the procedure of the curative petition. Now that is exactly what is being discussed in the Supreme Court today. But does that really hold water? I mean, eventually it's the Supreme Court that's going to tell us whether it does or not. But just take us through his defense as far as this claim is concerned.
Yes. So essentially there are two steps. At the moment, Yakub doesn't even have a foot in the door in the Supreme Court. So the first issue that's going to be decided upon is whether the curative petition, as I said, which was circulated to 3 judges, ought to have been circulated to 5 judges, including the 2 judges who rejected the earlier review petition. Now, if the court decides that Justice Joseph's view is the correct one and that it has to be circulated to 5 judges, then for the time being there will be a stay on execution of the death warrant. It would then go to the 5 judges, and the 5 judges would then have to take another view whether or not they want to consider the merits of the curative petition, say in open court after hearing arguments, because there is again a discretion. It can be decided behind closed doors in chambers and rejected in an order without hearing lawyers, or the 5 judges could then say, look, there is a difference of view amongst us, and therefore we feel that it should be heard in open court, and then there would be a foot in the door to go back to some extent to the merits which have already been decided. Now, we must keep in mind that it was circulated to 3, and now the question is whether it should have been circulated to 5. So even if it is circulated to 5, that will include the 3 who have already said no. So please keep that in mind. That would still be a majority. So that may raise another hurdle, and it would only depend whether, in the light of the other 2, one or both of them, taking a divergent view, the court would then say, look, let's hear this in open court. Otherwise, if on circulation again to 5, the 3 who have already taken the view take the same view, and the 2 others also agree with them, then you're probably not going to have any hearing in court, and it's going to be rejected again.
Right.
And we'll be back to the question of whether the mercy petitions are now to be allowed again or not.
Well, back to scratch in a way then. Akhil, do stay with me. Kapil, coming back to you, has there been a case so intriguing? I mean, this is really a last-minute decision in a way, with less than 24 hours left for the execution. Could you take us through any case that you've heard of in the recent past?
You see,
on similar lines?
Not on similar lines, and the office was doing research on that. Having said that, you see, death penalty is given in the rarest of rare cases.
Right.
That is what the Honorable Supreme Court has stated. And so if death penalty has been given in this case, it is one of the rarest of the rare cases.
Absolutely.
And the question then to the defense would be, or is it? So therefore, what the defense is trying to say at this moment, this is not the rarest of the rare cases. Please hear us on the curative petition. We will be able to demonstrate that this is not one of those cases which comes under the guidelines of the Honorable Supreme Court. In fact, way back in a judgment called Muttur, which was section 303 of the Indian Penal Code had been struck down, which basically stated that any person who has been handed over life imprisonment would be given death penalty. Now this was struck down way back, and now in today's date, this particular law is further being crystallized by the 3 bench that is going to sit today. So therefore, when you decide on the matter, the apex court is the highest court of our country.
Perhaps today's judgment could be a precedent for other cases that come up.
Absolutely, yes. So therefore, as law evolves by the judiciary, the law evolves even now when the matter is being argued, when the 3 judges come to a conclusion as to what would be the further course of action in such peculiar matters where the curative petition could not probably be decided by a process that was laid down by the Honorable Supreme Court itself.
Absolutely. Very intriguing case. In fact, I'd like both our senior lawyers to stay with us while we tell our viewers that with Yakub's slated execution for tomorrow, the Nagpur jail that has housed the 1993 convict is preparing for his hanging. The jail is under a tight cover of security after Intelligence Bureau issued an alert in view of the slated execution. Amita sends us this report from outside the Nagpur jail.
Just one day before the scheduled execution of Yakub Memon in Nagpur jail, the Supreme Court will decide in Delhi what is the fate of this entire case. I'm standing outside Nagpur Central Jail. Behind me you can see that the security has been beefed up in Nagpur Central Jail. The security's responsibility, half of the responsibility is given to QRT, that is Quick Reaction Team, and half of the responsibility is with the prison department. If we talk about the security inside the prison, then the half of the team of QRT is present inside the prison so that they can take care of the things inside. Also, outside we can see there is huge security deployment. All the gates of the Nagpur gate have been barricaded. No outside vehicle is allowed inside the gate. No officer from the prison department is still now speaking to the media channels, but what we are getting from our sources that the scheduled date, that is 30th of July, that is tomorrow, for that the Nagpur jail has made all the preparations. The main important thing is that yesterday the cousin of Yakub Memon was present here. He came to meet Yakub, but by giving the rules of the prison department, he was not allowed to meet Yakub. He was inside the prison for almost 3 hours with his lawyer.